can you give me a little bit more help? You go, well, what's the matter? Did you read the assignments? I mean, God, where was all that, you know? So here you got to let them know. You got to say, I want to know about something. But because we're lawyers, because we do have our own insecurities, at least some of us do, we might do other things. We might throw qualifiers in there that might make it overbroad. And if it's overbroad because they can't identify their outer limits, then on the face, that notice is defective. And what is that overbroad term that we all have or still use? What? The great Karnak! Including but not limited to. We love that because we don't have enough confidence in what we're doing. And what happens is when we say that, we've voided the entire notice, because if someone says, including but not limited to, Mark, tell me X, including but not limited to. How am I supposed to know how to answer that question? It's a weasel word, and we don't do weasel words. We tell them what we want to know, and they got to tell us. So let's talk about what we can talk about, okay? Facts. Real simple. And that's really the classic area of 30b-6. They got to tell you facts. If you ask them for facts, they got to tell you. They also have to tell you about sources of information. Where the hell did they get the facts? Where did they find them? How do we know those facts are accurate? That's a kind of a big deal. You know, because just because someone says something doesn't mean it's necessarily true. And you know, a thing that I think is real important that we lose sight of, 30b-6 can go to claims and defenses. Because some of the things, you know, some of my adversaries seem to have this misconception that discovery is only for me to tell them, you know, what my case is about. But if I want to know what their defenses are based on, I'm out of luck. That's work product. No. In-rate classic Mary leasing 209 Westlaw 1313311. Claims and defenses. And you know what? That's all over the country. But the big one, okay, so take a big breath because this is it. Ready? U.S. v. Taylor, 16 FRD 356, Middle District of North Carolina. The big dog. There is not one state in America where the U.S. v. Taylor isn't cited, and there are very few cases that don't cite U.S. v. Taylor. And U.S. v. Taylor stands for the proposition that it's not just facts, it's not claims, it's not defendants, it is the position of the organization. The designee must not only testify about facts within the corporation's knowledge, but also to subjective beliefs, opinions, interpretation of documents and events. Oh, baby, that is nice. I mean, tell us what you're claiming. Tell us what this contract means. Document speaks for itself, maybe to you, but not to the courts. How do you interpret this contract? How do you interpret this lease? How do you interpret this policy and procedure? And this is universal for any court that chooses to follow the law. Big, big case. So let's do some examples, okay? By the way, can you ask them their positions? Yes. Yeah, that's a nice one. You know, that's a big takeaway today. But let's talk about, you know, what Joe was doing, and you know, he had some great examples up there. I'm just putting small ones up. But say, I want to know the hiring protocols for Swift Trucking. Tell us about it. We want to know what's the protocol you use, or What is a testing protocol you have for a controlled substance? Or how about something like, how do you access and query onboard data recorders? You could go out and hire some vendor and pay them $100,000, or you could say, how do you do it? Can you download something onto your computers at the company? Let's find out. Bring it on. Do you have to get an independent vendor? Tell us. We want to know. Med-Mal, we got Med-Mal lawyers in here? Still left? How about something like, tell us any and all facts leading up to, concerning, or surrounding any sponge, soaking towel, or foreign object left in Megan Wilson's body. Huh? Huh? What are they going to say? Yeah, overbroad, QA, work product. It's otherwise a ridiculous question. Well, you can complain about it all you want, but that's verbatim. Med-Mal lawyers, write this down. Wilson versus Lackner, 228 FRD 524. It is a nationally cited case. This is the exact question that was litigated in Wilson versus Lackner, and the court said, you know what? Number one, this is a 30B6 deposition. It's not a deposition of the representative of the QA committee. Therefore, the organization, hospital, can go through and do the same thing that the QA committee did. They can interview people, they can look at documents, and they can get a position. Yes, sir?
Well, you said earlier in a couple slides back about getting someone's opinion. So you're talking about, like, saying, in your opinion, let's say, for instance, have your employees comply with your policies and procedures?
It's close. The question is, did your employees comply with the opinions? It's a little bit different. It's what is the position of the corporation as to whether or not the employees complied. It's not what the witness is, it's what the corporate or organizational or the government's position would be. But yes, they have to answer that. You like that?
I love it, man. That's good.
You can thank JD, you know. So here's what the court said. The lawyer, the plaintiff, should not be required to depose every single person in the operating room, get 15 different opinions or recitations of the facts, and then be left to trial to guess which position the organization or hospital would adopt. Now, you may want to take all 15 people to find the different stories, but you want to know what is the defense going to advance as a factual scenario at trial. And so Wilson stands for that proposition. It also has another nice little piece in it that said it warns the lawyers who are preparing the 30B6 designee to be very careful of what they show the witness, because if they do, they may be waiving attorney-client or quality assurance privilege. And I'll have a whole chapter in the book about that. So that's a good one. But the thing is, you can use this on other types of cases. I've used it on premises liability cases. I've used it on products liability cases. I've used it on Med-Mal. The Med-Mal has to be against a corporation or an organization like an LLC. If it's against a physician or a nurse alone, that's not an organization, that's an individual. And if you try to take the deposition of an individual under 30B6, I want to take Joe Blow's deposition on the following matters of inquiry, that's defective on its face. So let's keep moving with more, because there's lots of places. This is like the gift that keeps on giving. We learned that facts and sources of information about defendants' claims and defenses are relevant and discoverable. Okay? So we live in a world of word processing. So, affirmative defenses show up. And of course, my adversaries don't like to speak like human beings. They like to say things like, plaintiff's damages were caused by the conduct and or lack of due care of persons other than defendants whether individual, corporate, associate, or otherwise, and whether named or unnamed in plaintiff's complaint for whose conduct defendants are not responsible. Who talks like that? You know, it's like, if I'm going to give someone an orange, I'm going to say, here's an orange. You know, you don't do all this. So, but what are they saying here? It's somebody else's fault. And of course, you've got a scheduling order that says, if it's someone else's fault, you've got X days to invite them to the party, right? And of course, they have a Rule 11 requirement that there has to be at least some minimal basis for asserting this fourth affirmative defense or any other one. So how about this one? Why not ask the question, produce a person for us who will give us all facts and documents. Notice it's not legal theory. What are the facts and documents upon which you base your contention set forth in the fourth affirmative defense, bang, put it in right out of their answer. Bingo. Discovery's continuing. Well, you had to have some basis. Give us what you got. Well, it's work product. No, I'm not asking you for work product. I'm asking you for facts and documents. And I've litigated this a dozen times and always won it on the, we want to know who the other defendants should be, because the judge has ordered me to add them, and I'd kind of like to know who they are. And so there's a big one. Now, if you do this on, failure to state a claim, you're going to get into work product, legal theory, but we're looking for facts and documents.
But when you say you win it, do they withdraw the affirmative defense, or have you actually gotten information?
Pardon me?
When you say you won that, have you won it by getting actual information, or do they just withdraw the defense?
Yes. The question was, the question is, do they withdraw the defense or they give us actual information? It's both. I mean, sometimes I'll get things like, I'll have a car wreck and someone's killed, and so, I'm not waiting real long for that. It might be, 2 months, and it's in there, and of course there's statute of limitations, failure to state a claim, and latches, and the rule against perpetuities. You guys know what I'm talking about. Because the word processor just crank it out, and they'll just say most people aren't going to call them on it. Well, I do, because it's real easy to go to the court and say, look, Judge, all we're trying to do is narrow the issues. If this is a legitimate defense, then I got to do discovery on it. But I don't want to waste my time and the defendant's money chasing after something that just came out of a word processor. So let's narrow the issues. So the stuff like, I've literally had latches on a car wreck, that's less than 6 months old. Rule of perpetuity is, I may have been stretching it a little. But it's a cool term. I remember in law school, I punted on that one for the bar. I says, I'm not even going to try to learn it. I'm just going to take the 0 on that. I'm not the only one who's done that too. There's people in this room who don't want to admit it. So anyway, let's talk about some more stuff. Surveillance. How about, surveillance is kind of a big deal on premises liability cases. So we'll use a hypothetical company in Moses Lake. Electronic systems used by Walmart Moses Lake on May 4th, 2012. To me, that's pretty straightforward. I have had big box defendants where I've used that question, and I'll ask them, well, where were the cameras? What do you mean, where were the cameras? I didn't know you wanted to know that. I thought you wanted to know about what kind of surveillance system we had. There's a case about someone who got assaulted, or were there any cameras pointed at him? Oh, I don't know. But there'll be judges who'll just say, no. There'll be other judges who'll say, let's use more particularity. So what I like to do is start with a very big broad one and add other ones in. In this particular case, I had like 7 others, and I'll just go through one. So you can ask about surveillance. You can also ask about positions. Walmart Stores Inc.'s position and or opinion as to how the incident occurred when John Sullivan was struck on or about the head by the steel roller door at Walmart in Moses Lake. You know, my client's walking through the door, and then boom, and it comes down on his head. So what are you guys claiming happened? And that'll be an example we're going to use a few times throughout here. It's a case I had in Tacoma, Washington a couple of years ago. But you know, there's surveillance cameras issues, there's positions, what happened. It'd be kind of nice to know. Surveillance would be a nice way to find out about it. So, let's go back to the surveillance. Let's ask about policies regarding retention, okay? So we want more than just a surveillance film. We want to know what their policies were about the surveillance system's retention. So let's do a video on this one.
The company may have a legal obligation to preserve information that is potentially relevant to this incident. Accordingly, you must immediately search for and preserve paper and electronic documents, data, and physical evidence, including but not limited to the following. And that has a list of items below.
What is the very first thing you're supposed to preserve?
Surveillance video is on the list.
Kind of sets the standard, don't you think? Their own intent, you know, they got the 15 things to do in their investigation of an incident. Very first thing is to retain the video. And not just Walmart, other big box stores. I've had the experience that those things don't seem to be around. Anyone been in that same spot with me? You know, it's like universal. So what's the thing that comes into your mind? What is that video spoliated? Yes, sir.
I send the letter out immediately to keep it. And set out there to be spoliation of evidence.
Sure. But you know, you have a digital overwrite, so if you're not in there within the first 30 days, it's gone, right? Because virtually all surveillance systems, hospitals, nursing homes, big box stores, parking lots, they're digital and they stay on the server somewhere between 21 and 30 days. You got 3 days. They get overwritten. So it's kind of nice to have a policy to say if you know about an event, the very first thing, not the second, not the third, not the fourth, but the first thing you do is download that video. Because if it helps the defendant, they've got a defense there, right? So they should be downloading it and saving it. So, you know, I started thinking about spoliation when I get that thing, we don't have it. It was overwritten. We don't have it. What do you do? Well, again, courts are not going to take judicial notice of spoliation. Like everything else, there are elements you have to prove. And the classic elements are that the information would be relevant. They had notice of a potential claim, and it was destroyed. So, you know, we can argue all we want that it's relevant, and then they'll have an affidavit by someone who may or may not have read it before they signed it. So we need to build a record. Because the reason we lose motions a lot is because we have no record. We just seem to think logic and charm and eloquence will get you there. You know, and JD can do that, but the rest of us can't, you know? It's you got to have proof. So let's get some proof. Let's do some videos again. Let's start with relevance. So there were 3 separate cameras on May 4th, 2012 that would have picked up what happened, period?
Correct.
And if we had that video, there would be zero debate as to what happened, right?
I would have been able to, we would have been able to see everything that happened.
Right. And so then there'd be no fact question, at least physically, what happened, correct?
Correct.
I think we got relevance now, right? So do we prove that they destroyed it? Because that's a problem. Which, by the way, there's a case out of Washington that has a footnote in it that says anytime there is a notice of claim or notice of injury, that's a potential claim as a matter of law in Washington. So let's go to destruction. So for a period of 29 to 45 days, Walmart Stores, Inc. could have downloaded and preserved the videos of this event with Mr. Sullivan, correct?
That's correct.
Did they do that?
No, they did not.
Relevant? Yeah. Policy to do it? Yeah. Opportunity to do it? Yeah. This played a big role in our lawsuit because now all of a sudden we're saying you guys are creating a fact dispute that if you would have done and followed your same rules, there'd be no fact dispute. So I kind of like 30B6 on that one. And this was just on getting the documents. But you guys want to take it to the next level? You want to jump a little higher? There's all kinds of things you can do with 30B6. It's really cool. And one of my favorites, and this is really the subject of a 90-minute talk that I give, so we're just going to do a couple minutes on it just to kind of wet your whistle on it, and that's documents. Do you guys get the sense sometimes that when you ask for documents, your adversaries aren't being like completely forthright with you? Yeah? Or they have things like the checks in the mail. I'm going to get them to you. Trust me. I'm going to get them to you. And and it just goes on and on and on and on. Or then they finally give it to you, but they say, but objection without waiving, which, by the way, there's a whole body of cases that says that's unscrupulous. And if anyone's interested in it, just send me an email. In fact, it's called Network Tallahassee down in, I think, the Northern District of Florida. Fabulous case. So you can complain and you can bring motions to compel and you can fight about whether they're complying and whether they're not complying. And sometimes you win, but normally you won't because they'll have affidavits that saying it's like totally unreasonable and you can't get it because it'll take them 2 years to search the thousands of file drawers. But if you ask the witness about it, they'll say, yeah, I just would. If you say, if the judge ordered you to find something, how would you go about doing it? How would you know out of which 200,000 file drawers to go to? Well, I just go to the computer and find out which drawer it's in. But if you don't have that record, you lose. So how do we deal with that? Well, let's think outside of the box. Let's put the water in the peanut jar. Let's do a document deposition instead of a Rule 34 request. And the document deposition is you build the Rule 34 request into the deposition. You have a 30B2 component and a 30B6 component. You say, Mark, you're speaking in tongues here. 30B2, what are you talking about? Well, 30B2 is kind of like a subpoena ducis tecum. But it's a Rule 34 request that says the witness has to bring the document to the deposition. Well, Mark, why do you do that if they can just send it to you? Because the check's in the mail. If you have a deposition date set out 45 or 50 days or 60 days later, they have a deadline that they have to show up. They got to show up in a location with this information. So now you got a deadline, and you got someone who's got to answer for it. And you pick the documents. I mean, it's a schedule of documents. It's the same thing as your Rule 34 request, but it's in there. Just any cool document that you want, you can put in there. You say, well, that's great, Mark, but I note the records custodians all the time, and they bring some teenager in there who photocopies, you know what I'm talking about, right? The teenager comes in and says, I photocopied these records, it's all of them. And they have no idea. And the reason that's a problem is because back in the old days, You'd ask for the records custodian because you had to describe someone. But that doesn't do you any good because the records custodian doesn't know squat. So what we do is we go to our old buddy 30B6. And what we do is we say, I want a person to come and tell us what documents fall within this category. I used to ask for personnel files. Now I've advanced it to HR files. And you ask these witnesses some questions. And you say, what's in the personnel file or HR files? And you say, God, it seems to me you didn't say anything about, discipline or reprimands. Well, that's not in the personnel file. Well, where is that? Well, that's in the discipline file. That's happened 5 times to me. And so you want to, you have to know what you're looking for, but you say, what documents fall within this category that I'm asking for? And I've got videos on all of these things for the long talk. What is the reason, the purpose for creating these things, and how do you go about it? Because why that document is created shows the relevance for your lawsuit. What is the retention and destruction policy? So we track it, find out how it goes. Where are these documents or electronically stored information located? And I'm going to tell you right now, there'll be people here, I bet you this guy's got information on both his computer and his cell phone and maybe your server, right? Now, there will be corporations where you'll have the identical documents in 3 locations, but they're not identical. Personnel files might be one personnel file sent to corporate. A separate one is at the local office, and maybe there's one by the supervisor. Medical records. I see this all the time because I do a lot of nursing home abuse stuff. And we have the medical records that are in the chart, and then we have the medical records that are sent to the Department of Health, and sometimes they get changed somewhere along the way.